Right now at 4:30, a live look outside the Manhattan courtroom where jurors in Donald Trump's hush money trial have officially stopped their deliberations for the day. They'll be back at it tomorrow at 9:30 in the morning, and they're allowed to go up until 6 p.m. A jury is now considering 34 felony charges against the former president. He's accused of paying off adult film star Stormy Daniels to keep quiet about an affair before the 2016 election. Today, the former president called the trial rigged.
And that's why Queen City News has our chief legal analyst, Khalif Rhodes, here to talk about what happened today. And one of the things with the jury's already in deliberations, they have requested some information before they were let go for the day. A readback of the David Pecker testimony. What does that tell you?
It tells me a couple things. It tells me that some portions that we already knew, that we have a very intelligent jury. We have 2 attorneys on there, multiple highly educated individuals. And so they're tracking the flow of evidence that was presented before them, and they're going in chronological order. Pecker was the first person to start testifying. That was of substance, that was weighted, and they're asking, let's look at that conversation. Yesterday during closing arguments, the prosecutor mentioned that this is the nexus of where this whole relationship, where this conspiracy started. So they want to know what happened there, and they're asking for the transcript so they can see exactly what happened, because they don't have that back there with them. They have maybe pieces of evidence, but they don't have the transcripts. You don't have videotapes of it. You don't have audio tapes of it. None of us can see what happened in there. But they sat there for 5 weeks, and they may have forgot what he actually said. They have their own individual notes. They've been taking notes the whole time. But maybe your notes are different than what my notes are. So let's see exactly what he said. Let's go back and ask the judge, can he show us that? Clearly something that if I'm the prosecutor, I'm liking. If I'm defense, I'm not happy that they're asking for that. But I am happy that they're back there, and they're back there this long. Because typically, I'm not a jury expert, but I would say typically that means that the longer they're back there, the more likely that they can't come with a consensus.
Well, so what else are they looking at here? Because there's 34 different charges, so they have to go through all of those one by one.
They do. They have to go through all one by one, and then so you got to look at it from a couple things, because we got a couple different scenarios. First, you can get a guilty on all 34 counts. You can get a not guilty on all 34 counts, but we need something called unanimity. We need them to be unanimous on both sides. If you're going to convict, not just on all 34, it could be one of them, but if it's a conviction on any of them, it has to be unanimous. Just like if it's a not guilty on any of them, it has to be unanimous. That's the only way we get to a verdict. We can get other variations of a non-verdict. We can get a hung jury, which is, you know what, Your Honor, we couldn't come to a decision. We've tried. They may come back tomorrow and say, Your Honor, we've tried and we can't come to a decision. The judge will normally give them a push and say, well, you know what, go back there and try to come up to a decision, because they want to get a verdict. And then if they can't, we'll get a hung jury. And those are things that happen routinely within this process, specifically when you have multiple charges and you're trying to look at documents and paper type of cases like this. That's not, like a smoking gun with a video. You're following a paper trail, and sometimes that paper trail, the trails don't lead to where the prosecution wants, and so questions are good for the prosecution.
So tomorrow is when we could hear some sort of verdict, and how would we know? What will be some of the signs that they let to know?
Well, first of all, you'll hear the bell, because one of the signs, like in most courtrooms, is that you'll hear a bell, and the bell is that either we have a question or we have a verdict. Today we heard a bell, or we had notification that there was a bell being rung, and that notification was that they had 4 questions. I think that I'm again, everyone becomes an expert when these types of things happen. Everyone now is a jury expert. But from my experience, what I can tell you is that questions are good. Tomorrow, I think they'll have more questions, because if they're going in chronological order, they'll have questions about Cohen's testimony, specifically his testimony in a jury instruction. That pattern jury instruction that talks about not being able to weigh his evidence only and having it to be corroborated by other testimony. I can guarantee they'll have questions about that, just like they had questions about all of the jury instructions. You got to look at it. This is 50+ pages of jury instructions. Just a reasonable doubt is a page and a half. And so for the lay person, a person that doesn't look at this every day, this can be complicated. For most attorneys, it's complicated. And so ensuring that they get it right, this is what you want. You want questions, and you want to ensure that they're not just trying to blow by this and make it seem like they weren't paying attention for the last 5 weeks.
And when that verdict does come down, if the former president should be found guilty, you've said before, you do really see jail time here, because it is in the cards, but do you see it?
I'm not Miss Cleo, but I can tell you for sure there will be absolutely no jail time. 4 years is the maximum for this type of charge, but I mean, he's a first-time offender. By all means, he has a number of pending criminal cases, but it would be extremely confusing if the judge sentenced him to anything outside of probation and fines and fees for this type of case. It's a paper case. It was, I won't say a victimless case, because it wasn't, but it was not a violent type of case. And again, his criminal history, his past, his likelihood of fleeing, but it does open the door for other things. The state of Florida, if you're convicted of a felony, you can't run for office. You can't vote. there's a number of things that will happen if he's convicted of the felony offenses. And so that may trigger more than him going to prison for sure.
Boy, that is a big question right there. And obviously we're going to have to wait and see. And I wish we'll leave it there right now. And Chief Legal Analyst Khalif Rhodes, thanks.